Mommy, I video. Stop and confirm, please. Mommy, go into the vehicle.
You call them anytime.
Go into the vehicle. Mommy, say go.
That's what I'm saying.
You're going to the headquarters.
Okay.
Go into the vehicle.
No, going on the vehicle.
Mama, you video.
Leg off of me ear.
Mommy, why is that?
She don't know right now.
She leg off of my ear. Go into the vehicle. Mommy, go into the vehicle. Mommy.
Mommy, relax. Leg off of me ear.
Mommy,
She asked me so.
Mommy.
Leg off of me.
I want to know what. Officer.
Just go in the vehicle.
No, but she. Mommy. Put up his hand.
Leg off of me.
Mommy, stop it, mommy.
Welcome to Irie News Channel, where you can expect to get cutting-edge news, views, and reviews. Don't go away. We will be right back.
Hello everyone. Good day. Thank you for tuning in today, and I just want to say a big thank you to all my viewers and my subscribers for helping me to make my channel grow. They say one cocoa full basket, and I just want to say thank you to my 28 subscribers. I really appreciate you for helping me to make my channel grow, and I am imploring my viewers, those who are tuning in, if you find quality in what I have to say over here, please just hit the subscribe button and click on the notification bell. Yes man, give me a like, give me a thumbs up so that my videos can show up more in the algorithm. Again, I just want to say thank you for your support. This week seems to be a very festive one, as we have a number of things happening. For instance, we have the woman who resists police arrest. That video has been making its rounds. Yes, a screenshot from a video showing a woman being arrested by a policewoman on the compound of a school in a St. Catherine's school on Monday. Then we have a senior cop apologizes for comments that he made branding firearm holders as cowards. And of course, the Vybz Kartel topic is still a very hot one, as he had his retrial hearing come to an end this week. His lawyer will give his thoughts on what happened, and we will have Dionne Jackson Miller weighing in. She will be giving a summary of everything that happened. You don't want to miss that, so stay tuned so that you can hear both sides of the story. And last but not least, pew pew goes off inside Oteria's classroom, one student cornered up. These are the stories that we have for you. Stay tuned. And remember to please like, share, and subscribe. Yes, please like, share, and subscribe. Yes, man. Click on the notification.
Mommy, I video. Stop and confirm, please. Mommy, go into the vehicle.
You call them anytime.
Go into the vehicle. Mommy, say go.
That's what I'm saying.
You're going to the headquarters.
Okay.
Go into the vehicle.
No, going on the vehicle.
Mama, you video.
Leg off of me ear.
Mommy, why is that?
She don't know right now.
She leg off of my ear. Go into the vehicle. Mommy, go into the vehicle. Mommy.
Mommy, relax. Leg off of me ear.
Mommy,
She asked me so.
Mommy, I want to know what. Officer.
Just go in the vehicle.
No, but she. Mommy. Put up his hand.
Leg off of me.
Mommy, stop it, mommy.
Hello, she come out and she say, just relax
Nobody.
Mommy.
Go in that vehicle. You have to go in that vehicle.
Hey, officer, just release her here.
Release the mama. She under
I want
arrest.
to see her under arrest. How many times I should have to close? I want to see me.
now you come from me
Go in
first.
that vehicle.
Go in the vehicle.
You come trouble me first. If the lady can talk to you, she can ask someone, she said, come on and come on.
Are you pointing at my face? So we tell her, don't point at
Me
me.
didn't lick you. Me ask
You know
him.
that is an assault?
Me ask him me
And I'm
lick
going to
you.
ensure that I charge for everything.
I don't care.
Good. Go into the vehicle. Mommy, just Mommy, you're just making things worse. Relax.
Shusha asked me what kind of work I said I did not come here to disclose. You come out in a house. You're not supposed to disclose my job to you.
Him from one friend down there.
Next year. And you come meet me first. We never did the trouble you.
Him from one friend down there.
Yes, I come up and come phone and I said to this. Me and the lady I got treat you to come lick me. We never lick you.
I like this way. Next year. I like it. Mommy, relax. So whether you take it or not, you're gonna have to go in the people.
Leg off
So
on
if
my
I say
ear.
relax yourself on the
Let
place,
me let go off on my ear.
So release your hand, release your hand from the clothes.
She's gonna release you.
Release your Sir,
And you make sure say I have no money to buy about my chain. There. Just make sure I am broke.
we realize. How is she taking the deal?
Oh, where back with her girl?
Next door. Something enough. We're not going to uncover or something.
We're
not a tie strap.
Let go for me.
We'll have uncover.
You can't drive so you can't make it crash.
Yeah, we need a tie strap or something.
She alone can't go in and then she'll make it crash.
Let your bike. Let your bike. Let go for me. Let your bike. Tell them to get off the phone. Put your off the phone. Pretend I lie, yeah.
What's that?
What's everything that you cover up?
Hey, woman, move from here, say now. Move from here, say. Excuse me, let me get up and sit in the chair.
Stay there, miss.
So put the handcuff where you put on me. Put the handcuff.
Stay there. Mister, stay. Chin.
Put the handcuff on me. You see, I put the handcuffs on me.
Stay there. Look here now. When I send the unit come to your 6 now, don't want you have my clothes now.
Done. Renee, come up a police station here. The police are come up a school and she has said the police have left the premises, right? Me I go to the gate, and when me I go to the gate, she come when him the son. But point up my hand, she come lick me.
You never know. You point your name on my face, tell him.
Yeah, but that not your right to lick me.
You're an idiot.
The
You're
police
right
girl.
because you're starting. Police girl like you.
So
How we are called girl?
just
A girl let them she want to give me a number.
take your foot off of me.
No call nobody for you.
Me screen to have the phone because
Put your foot to the vehicle. Move your foot.
Mr. said do not make any calls. You're under arrest.
Me not make no call. No call me.
Miss, what I
And
just
the watch
said.
me a turn off. The watch me turning off. They say me not make no call me a turn off the watch. Look and see if I call
I'm
me.
going to ensure that I arrest you without bail.
Arrest me and do anything. The law will come through.
Mr. talk to you about the phone.
I turn off the watch. I don't have a phone. It's the watch.
The watch is a smartwatch.
Yes,
miss.
what I am
and
saying.
I'm saying, don't go
turn
on.
it off. I just turn it off. They say me not for you.
So based on this video, a number of persons have a lot to say. Some persons are saying that the police officer, she was within her rights to do what she was doing. After all, she had very little to work with. They didn't even have an handcuff, as you could see. Yes, she was doing what she had to do, and she was using her body parts as much as she could to subdue and arrest this lady who was visibly resisting arrest. Some persons are saying that she used excessive force, while some persons are saying that if the lady had complied, she would not have subjected herself to such disgraceful behavior. What do you have to say? What do you think? Do you think that the police officer went overboard? Was she unprofessional, or did the lady deserve what she got? The Jamaica Constabulary Force is reminding the public to stay calm and do not resist arrest. The Constabulary Force says the police are empowered under the law to make arrests, and there are proper channels for persons to challenge being taken into custody. It issued that reminder amid criticism arising from a video showing a confrontation involving a policewoman and a woman at a school in St. Catherine. The video has gone viral on social media platforms. The police report that on Monday, a team from the Spanish Town Police Station responded to a call from a primary school administrator requesting assistance to remove a disruptive parent from the compound. According to the police, despite multiple attempts by the police to engage the individual peacefully, the situation escalated. The woman was later arrested, and charges such as assaulting the police and resisting arrest were laid against her. The JCF says it is important for all members of the public to cooperate with police during any interaction, especially during an arrest. In these circumstances, it is important to remain calm and comply with the police instructions, it stated. The JCF is committed to maintaining public safety and upholding the law with professionalism and respect. We urge everyone to assist in this mission by engaging with our members appropriately. Together, we can ensure that interactions between the public and the police are conducted safely and respectfully. Deputy Superintendent Paul Bernard has issued a public apology for his remarks. This comes hours after the police high command reprimanded him for describing licensed firearm holders as cowards. Bernard, who is the operations officer for Zone 1 in the St. Catherine North Police Division, was critical of some licensed firearm holders, including parochial councillors, not for assisting law enforcers in the fight against crime. He had raised a point during Thursday's monthly meeting of the St. Catherine Municipal Corporation about the deadly violence gripping sections of the division. A lot of us are cowards, even firearm holders inside here. Most of you are cowards. Tell me when last you hear a firearm holder shoot somebody. A lot of you are cowards, man, who not leave the fight to police alone, the officer claimed then. In response, the High Command on Monday morning said it considered those remarks to be reckless and not representative of the values and professional standards of the JCF. Following that broadside from his superiors, Bernard wrote and recorded an apology, which was posted on the JCF's Instagram page on Monday afternoon. Here is a video clipping of what he said then and the apology that he made afterwards. Do you believe that he should have apologized? Do you believe that what he said make any sense? Do you believe that he was out of his way making those comments and that he should have just kept those comments to himself. What do you believe? Let me know. Comment in the comment section.
What do you look for, Miss Murphy? They'll see you and video you. But they see the criminal, they say, I'm the G that man. Because he can buy my Roman book. Coward. A lot of us are cowards. Even firearm holders inside here. Most of you are cowards. Cowards. And I'll stand here and say that. Tell me when last year a firearm holder shoot somebody. A lot of you are cowards, man. Firearm holders inside here and then go knock up to their car. A lot of you are cowards. Gonna leave the fight to police alone.
I am Paul Bernard, a Deputy Superintendent of Police attached to the St. Catherine North Division. Through this medium, I would like to extend my deepest apologies for the comments I made at the recent meeting of our municipal corporation. The statements were inappropriate and do not reflect the values and standards upheld by the Jamaica Constabulary Force. I recognize that my remarks were an error in judgment and were not in line with the principles of stakeholders' engagement that we, as members of the Jamaica Constabulary Force, are committed to. As a 38-year advocate of community-based policing, I am deeply sorry for any distress or harm my words may have caused to the community, my colleagues, and the wider public. The success that the St. Catherine North Division, and by extension the wider JCF, has been able to achieve have come through building effective partnerships between the police and our citizen groups. My comments were not reflective of the transformation in quality that we have engaged in. So I fully understand the gravity of my actions, and I'm prepared to face the consequences determined by the Jamaica Constabulary Force I command. I am committed to learning from this experience and ensure that such behavior is never repeated. Once again, I offer my sincere apology and ask for your understanding and forgiveness.
Last week, everyone watched with a range of perspectives on the keenly watched court battle between the prosecution and defense relatively to whether dancehall entertainer Vybz Kartel and his 3 co-appellants will face a new retrial for the 2011 outing of Clyde Lizard Williams. Then, even though the judge said that it would not go beyond 5 days, the matter was then extended for a 6th day on Tuesday, June 18, for closing arguments in the Court of the Appeal. Vybz Kartel's lawyer, Isaac Buchanan, spoke on what he thought about the trial hearing, and then you will hear what Dionne Jackson Miller has to say. Both of them, of course, will give you 2 different perspectives, and then it will be left up to you to deduce what it is that you will from what both of them have said.
So today is the final day, actually roll over into day 6.
Yes.
And to just provide a recap of all the submissions made and the discussions happening over the past 5 days.
Wow, it will require great memory to do all of that. But certainly the defense is saying no retrial. The prosecution is saying there can be a retrial. There was a breach of the fair trial right, which was the central issue of this case, and whether or not the court can order a retrial in the circumstances. Certainly for the defense, we would have presented affidavit evidence, which was a plethora of documents. As you can see, it went over into day 6, and even at the end of day 6, there were so many documents that the court was inundated with information that they now have to go through. I just wish to make clear that because of this, it is one of the reasons why the court now has to go through the information and have a written judgment, because this is a high public interest matter, and so the explanations coming from the court will be of great value.
Something in your submissions that you made that I heard you present was saying, they were suggesting the prevalence of these kind of murder cases. Another thing that you had mentioned, breach of constitutional rights, and also public interests. Do you think those in that submission, do you think it holds any weight, or will it affect any decision made?
In terms of the prevalence of the offense, the prevalent Jamaica is a high crime society. It's recognized. There is resource in terms of information that puts Jamaica as a high crime society. I think what we need to appreciate is that when it comes to constitutional rights, it shouldn't be taken lightly. And so if we're to give effect to the rights, it has to be on a spectrum. So while it is, I'll just say, the prevalence of the offense, it has to be weighed with the presumption of innocence. The circumstances of the court resources, the length, all of these are things that when it comes to the interest of justice. For instance, we have at least 744 cases this term alone at the Supreme Court where these persons either need to be on bail or want their matter pushed forward. If the court has to push back, those persons are going to be in a position where they'll be crying to the court about delay. We have many issues within our justice system. We're not perfect, we're a developing country, but what this case shows is that we can, from the defense bar, that's the Bar Association, the prosecution side, and the judiciary, give advice to the legislators in terms of how to put in statutory safeguards to ensure that certainly for a retrial like in England, the limit is 2 months, and we've gone beyond that.
Let me get 3 months. Can I ask you what's the if you spoke to your client and what his feeling and the progress of the case?
Certainly, in terms of the progress of the case, the client is anxious. There's not much you can tell a man who wants to get out of jail as to why is it being delayed or anything like that. It is a continuing breach, and that, as I said, that's certainly where it is. And so I have no comforting words for my clients, save and to say that the court has now made it clear that they're mindful of Mr. Palmer's illness, they're mindful of the length, and that certainly they have given a time, as in the maximum time that they will be able to write the judgment and be able to hand it down.
As you mentioned before, and the judge had alluded to a lot of cases, as you mentioned, 700 that are waiting response in the system. Do you think that this case can be pushed, will be affected by the delays and all of that?
This case?
Yeah.
I don't even know to respond to that. My response is always God on time. This case is finished. I from the defense bar, fresh justice is something that a concept that we ought to be looking at in terms of trying to ensure that persons who are put before the court for the very first time, that their matters don't fall into the position that the appellants are in this particular case. So in terms of pushback, the judge did make it clear that there will be some pushback for other cases to ensure that in light of Mr. Palmer's illness, that they get the judgment out at the fastest possible time. And the blame is now at the hands of the prosecution and the defense because we inundated them with paperwork, which was my defense is it was necessary to do so.
Are you confident in what the ruling will be?
I'm always confident. I'm always confident. Is God on time? I only speak positive to the universe.
Okay. Anything else you want the public to know?
We are at a time where constitutional amendments are being spoken about. It is your right to know your rights. The Constitution is the only safeguard against your interests and government. Don't lie carelessly and take it for granted because it could be you.
You mentioned something earlier that not you specifically, but that the charter should not be empty promises. Do you think that's falling on that here?
Well, if it says you have a right to life, it is a promise that the charter is saying that right will be protected. And if unfortunately it is that you have lost your life, how it is that if it's by the state, how the state guards it, how the state gives effect to it. Same thing, your freedom of expression. The media has a right, which is why the court has made provisions so the media could come and observe, so that they can disseminate information. These are promises to the Jamaican people, to the citizens, and if these promises are to be kept, it is only the court that can give effect to it, because state actors will breach it. Your citizens, the Constitution makes provision under Section 13.5 that horizontally a citizen can breach your right. It is the court that you go to say my right is being breached. When I made mention of the lady Whistledown situation. Sir P, Miss P, Lady Whistledown, they could probably all be the same. I don't know. But the danger of that is they are allowed to defame you. They are allowed to cast aspersions on your character. They are allowed to say anything, and the court is unable to regulate situations like that. So if the rights are to give effect, there must be some remedy to protect you, even from...
Alessandra Beach, attorney at law for the first and second appellants, Sean Campbell and Aditya Palmer. We are happy that the information is now before the court for them to give their mature consideration. We admit to have inundated the court with a plethora of documents, volumes, and so we know that they would need time to take all of that into consideration. There are lots of reports, lots of affidavits. We believe that we put forward all that was necessary to establish our client's case and their wish to not be retried in this matter. Well, that's the thing. It has to be considered in the round. So there are lots of factors that we have to take into consideration. It's really a balancing exercise, and what weight is given to each of the factors separately and cumulatively is a matter for them now, given the evidence that is before them. The length of time, the seriousness of the offense, and the constitutional issues which we hope and which we urge to be brought to the forefront, given that our system espouses constitutional supremacy. So we urge the court to start with the constitutional considerations. Well, in all matters where a retrial is ordered, they would treat it expeditiously. That is the general principle. We cannot say what caused the delay in the two matters that you have mentioned, which are the Hamilton and Taft matters. We hope that, and we know that the courts will take these things into consideration when they are deciding whether or not this matter should go for a retrial, given the status of those matters that have already been sent to retrial and how they have been advancing through the court system and the pace at which they have. As you note, no trial date has been set. For one of them, a bail application is upcoming, and that is just now after some time has passed. So those are considerations for the court to grapple with when they consider whether or not it would be in the interest of justice to order a retrial in this case.
Prosecution says it's in the interest of justice for there to be a retrial. According to acting DPP Claudette Thompson, she said the court shouldn't dismiss a matter like this because of a technical blunder, because it's in the public interest that people who have been accused of crimes should be tried and, if convicted, should be brought to justice. She named the factors she said are in favor of a retrial: the seriousness of the offense, that is murder, the prevalence of the offense in Jamaican society, also availability of witnesses. On a previous hearing date, questions had been asked about that. Well, she said witnesses are available, and she also spoke about the strength of the prosecution's evidence. 2, in responding to the comment, the submission about the strength of the prosecution evidence, attorney at law John Clark, who is representing the accused men, who is speaking on behalf of the accused men, raised questions about some of the exhibits. He said there were 25 exhibits in the first trial. Now, during this hearing, the prosecution presented a list of exhibits that they said had been verified as being available in the event of a retrial. But Mr. Clark said, hold on, 25 exhibits in the first trial, but there are only 16 listed here as being verified. He said 2 of the most important exhibits were not listed. 1, the DVD containing the video of the murder. 2, the DVD containing the voice notes supposedly sent by Kartel. He also said that some of the exhibits relied on by the defense were not listed as verified either, such as the signature of the sole eyewitness Lamar Chow, also a letter to the public defender. According to Mr. Clark, the court now has to take into account the fact that these vital exhibits have not been listed as verified when they're going to be assessing the strength of the prosecution's case. 3, the court looked at the sentences that the men had received during the first trial, at the end of the first trial, and looked to see whether or not they would be prejudiced this time around by the length of time they've spent in custody. Now, under the Offenses Against the Person Act, a person convicted of murder in this type of circumstance can be sentenced to life imprisonment. And in that case, the court has to set a 15-year minimum before they can be eligible for parole. Now, both Kahira Jones and Sean Campbell, all the 4 men, I should say, had been sentenced to life imprisonment, but different time periods in terms of eligibility for parole. So Kahira Jones and Sean Campbell had been sentenced to life, and they could only be eligible for parole after 25 years. In the case of Andre St. John, it was 30 years. In the case of Adidja Palmer, it was 35 years without being eligible for parole. What the court looked at is the length of time the men have already been in custody. That is nearly 13 years. If a retrial is ordered, they could be in custody another year, perhaps another 2 years. Say they're in custody for 15 years, it would mean that they would then have served at least the minimum time that the court would have ordered in a sentence before they could be eligible for parole. The response of the acting DPP to this was that, well, given the circumstances of the case, she wouldn't envisage that eligibility for parole would be set as low as 15 years. Therefore, she doesn't think they would be prejudiced. 4, the judge asked, why is this case different? What makes this case special? And she was asking in the context of the fact that we've heard recommendations and talk about the possibility of this case being set as a priority case to ensure that the men who have already spent all this time in custody wouldn't then be spending another long period in custody if it is that they're not granted bail if a retrial is ordered. Now, the comparison the judge made was that of the case of Trevor Taff. Now, Trevor Taff was convicted in 2016 for the 2012 murder of the mother of his child. Her body was found on his property in a septic tank, and obviously she had been killed in a pretty terrible way. The body showed stab wounds. She had been decapitated. And what the court said, what the judge asked is, hold on, here is a case involving distressing circumstances, a young woman, a mother of a child, and she was killed in pretty terrible circumstances. So what makes this cartel case so different and so special that it should leapfrog cases like Trevor Taff that are waiting for retrial? What the prosecutor said in response was that, well, they're not trying to compare victims of the case. What they are saying is that in this case, a cartel case, they're ready for retrial. They'll be ready as early as the next court term, which begins in September after the summer break. And 5, looks like we're going to have a speedy judgment here. The presiding judge, Marva McDonald Bishop, said the court is going to be working assiduously to deliver a timely judgment. They're aiming for a judgment by the end of this current court term, which ends at the end of July. So, of course, we'll be watching out for that. I'll be keeping you updated on everything. Make sure you check back here. And until next time, thank you for joining me, court.
And pew pew goes off inside Ocherius classroom. Student corned up. A student of the Ocherius High School in St. Anne was on Monday corned up and injured on the school's compound. A reliable source said that a schoolboy took an illegal pew-pew to the educational institution and it went off inside a classroom, hitting a schoolgirl in the leg. The incident occurred sometime after 1 p.m. The injured child has been rushed to the hospital. Several students were left shaken as a result of the incident. Police are currently at the institution, which is located in the resort town of this parish. It is understood that the pew-pew has been seized. And you may be laughing and wondering why I say pew-pew. It is because of the sensitivity of YouTube. When you use certain words, your videos are suppressed. So you will hear me using different words for certain words, but in the Jamaican context, we will all understand what we are saying. Those were the stories for today. Thank you for listening. And as usual, please remember to like, share, and subscribe.